I reminded of the words of Justice C.R. Krishna, who once said, "Law is not brooding omnipotence in the sky, but a dynamic process of human relations." This statement underscores the importance of understanding the law as a living, breathing entity that shapes the lives of individual and society. In this gathering, there will be many students who are dreaming of becoming judicial officers. Judgeship, just as the earlier speaker said, or earlier the Lordship said, judgeship of any cadre is a noble profession, but demands not only deep understanding of law, but also a commitment to upholding of justice, equity, and fairness. The judicial service examination is a critical milestone in your journey if you are aspiring to become the judges, and I am honored to share with you the insights and the practical advice on how to prepare for a prestigious examination. First of all, you must know what is the procedure. How we have to prepare for the examination is, you must know what it is. Generally, High Court selects the judicial officers of the district judiciary through examination and interview. The selected candidates will be appointed to the state through the notification issued by the governor. Ultimately, you are appointed by the governor. Recruitment to the cadre of civil judges is governed by the Karnataka Judicial Service Recruitment Rules 2004, which came into force on 9 September 2005. By repealing the Karnataka Judicial Service Recruitment Rules of the year 1983. Under these rules, minimum qualification prescribed for direct recruitment to the cadre of civil judge, at the time it was designed as in series, was a degree in law and practice as an advocate for not less than 4 years. When you are all joined the service, there was the 4 years qualification was there. Ours batch is the last batch, which had the prescription of 4 years practice. After all the appointments to come afterwards have come without service, or that service was not mandatory. That was not the mandatory requirement. Under the rules, minimum qualification prescribed for direct IRR. Under the present rules, the requirement of 4 years of practice was taken away, and a law graduate who is enrolled as an advocate has been made eligible to become the civil judges. The requirement of practice as an advocate for 7 years is still there for the appointment of district judges. So as I told earlier, there was a two cadre, one is the civil judge cadre and one is the district judge cadre. To appear for the examination of the district judge cadre, you have the practice of 7 years. The requirement of the practice as advocate was taken away by giving of the direction of the Supreme Court in the case of All India Judges Association vs. Union of India, 2002, reported in 2002 for SSC 247. The direction is at para 32, and it says that why that 4 years practice was taken away. The reason is that with the passage of time, the reason given in that judgment is that with the passage of time, experience has shown that the best talent which is available is not attracted to the judicial service. A brave young law graduate after 3 years of practice finds the judicial service not attractive enough. So that was one of the reasons why that 4 years or 3 years practice requirement was taken away. So the recommendation was like that. The recommended that a fresh recruit into the judicial service should be imparted training of not less than 1 year, preferably 2 years. So now after appointment, you all will have 1 year's training in Judicial Academy. That will be given by stage wise. It's 4 months each. It will be completed in 3 sections. On the passage, so now there is a strong urge of the stakeholders, that is including advocates and judges, that the requirement of practice as an advocate is to be reintroduced. The reason being assigned that lack of practical knowledge is hindering them from discharging the judicial work properly. In All India Judges Association vs. Union of India, that is in WP number 1022/1989, interim applications were moved to make the practice as an advocate is mandatory. The bench of the Supreme Court has heard the matter elaborately on the issue of whether minimum practice is required for applying for the judicial exam and a result for the judgment. Because of this, the Karnataka High Court has kept the process of appointment in abeyance till the judgment is pronounced in that matter. Actually, a notification was issued for the appointment of 158 civil judges. Now it is put on hold, awaiting for the judgment to be rendered in that case. If prescribed period of practice is made mandatory, then you have to join the office of a lawyer which practices in a trial court. It is better, and it will help you in great extent to understand the practical aspect of the judicial work. In here, I want to stress upon here that if the 2 years or 2 years practice is fixed, then you have to join to the office of an advocate and you should have the practice certificate while applying for the judicial examination. I don't know whether it will be made as a mandatory or not. But the line of thinking goes that there will be some period which is prescribed. It may be 1 year or 2 years or 3 years. I think maximum will be the 3 years. I think so. It is my, I have no idea about that. I'm not sure on that. You need to understand the, first of all, while examining any examination, any competitive examination, you need to understand the method and pattern of examination and the prescribed syllabus for the examination. This will help you to design the study pattern and the subjects to be covered. There is a difference between preparing for the examination in the school or the college or the competitive examination. Competitive examinations are more on practical applications. So competitive examinations are more on competitive applications rather than theoretical. Reading for college exam intended to focus on in-depth understanding and application of the concepts, while reading for competitive exam emphasize the speed, comprehension and ability to solve the problems quickly and accurately. Why I am saying is that because once you select as a judicial officer, immediately you have to solve the problems. So theoretical part only will not help it. So there will be a writing of judgment, translations, there will be small problems will be given. The answer will be objective type. They will give you one set of facts and say what is the answer for that. That will be the form of that. So you have to collect the question paper of previous recruitments. There are also difference between the collection of question papers for the examination purpose and for the recruitment purpose. See, there you are not collecting the answer papers to know which questions are repeated again and again. The purpose is totally different. So question papers of previous year have been collected to ascertain which questions are repeated. That is the general question. So I will get the question paper, that is, and all some publications will also be there. And then concentrate on those questions. However, it should not be the purpose which I intended or what I am telling is that you have to go through the previous question papers to understand in what way questions being asked. In what way, what how, in what mode the question being asked and what is the pattern. It will help you to understand the exam patterns, identify the important topics, assess the difficulty level and improve the time management. That is also very, very important in judicial examinations, especially in translations and all, how to manage the time. I will touch upon that subject a bit later. Then confidence, boost up the confidence. Why? How it will be boost up the confidence? If you go to the question papers and if you answer that question papers, you will say that yes, I am competent to that. In that way, you will boost up your competence, thereby aiding the effective preparation and success. Keep in mind that sometimes I am telling that why you don't see the repeated questions, especially judicial examinations or any competitive examination, because now what is there? Artificial intelligence will be used to see that only non-repeated question papers will be come in your question papers. That is happening. So keep it in mind that sometimes the assistance of technology will be used to prepare in such a way that none of the questions of earlier question papers are repeated. You all know, I think you know all of that. We will get the previous question papers of both the district judges and civil judges in official website of Karnataka High Court. You will get it. There is a separate link is provided. I think you can get it. If you didn't get, or if you want the guidance, you can contact the senior plus, surplus, or any persons of that. With that background, let us see what is how the recruitment takes place. Method of recruitment on the basis of the aggregate marks obtained in the competitive examinations, main written examination, and viva conducted by the High Court. The competitive examination of civil judges has consisted of 3 stages. One is the preliminary stages, then is the main written examination, then the viva. The marks secured in preliminary examination is considered only for the eligibility to the main examination. You will keep it in mind. Because I scored 90 marks in preliminary examination and that will be carried forward. There is no question of carry forward. But the main written examination marks will be carried forward into the interview level. On that basis, your ranking will be ascertained or whether you are selected or not will be decided. I will ask that will be later. It's better. So there will be preliminary examinations. So preliminary examination will be conducted by the objective type question papers consisting of 100 marks, and the syllabus for the set examination shall be in the following manner: Code of Civil Procedure, Negotiable Instrument Act. We will all get it in a notification. Just I want to tell what it is. So specifically, Indian Constitution, Karnataka Rent Act, Code of Civil Procedure. Just newly added are the Bharatiya Nagarika Samhita, Indian Penal Code, Bharatiya Nyaya Samhita, Indian Evidence Act, Bharatiya Sakshya Niyama, and general knowledge. Test of reasoning and mental ability. That will also be tested. Main examination translation paper, there will be 100 marks. There will be one translation paper and candidates will be required to translate the passages in English to Kannada, Kannada to English. Understand today itself, be careful that both languages are very, very important. Don't think that English language, I am very proficient in English, so I can get through the civil judges examination, forget it. Today itself you forget it. If you are proficient in only one language, no, you should be proficient in Kannada language, English language. You can write the examination both in Kannada or English, no problem. But you must have the mastery over the both languages. So law paper, that is again the syllabus is provided. Look into that. Law paper second, again there will be revision. There will be a third paper, framing of charges and writing of judgments in criminal cases. Similarly, framing of issues and writing of the judgments in civil cases. That is what I am studying. It is a more on practical aspect and not on theoretical subject. You will be assessed, you will be evaluated based on your practical knowledge. That is why I am telling that if any reason, if the time is prescribed, if practice time is prescribed, you have to be very careful. You have to think of which office of the advocate and you have to do further practice. Computer test, that will be 25 marks. Again, if it is part of your syllabus, okay. Otherwise, you have to get the computer training also. Eligibility preliminary examination, medical examination. I think you will go to this notification, you will get all the things and not because of time is running out. There will be probation and training of 1 year as of now in Karnataka Judicial Academy that I already told you. So that is the again and once again I am reiterating that the purpose of judicial examination is to test your ability to analyze the facts and apply the legal principles and arrive at the reasoned conclusions. We have to keep abreast of the amendments and the decisions of higher courts and recent developments in the law and also on general knowledge. In preliminary examination, more than 10% is out of law subject. It is on general subject in preliminary examination. Joint study and group discussions will help in great extent. It is one way of the method you can use. Don't rely on the books which are available in the market for judicial examination preparation. I will suggest you certainly don't rely on that because it will help you not. It will not help you because you may understand because when you are asked ready, there will be 30 marks, 30 questions. Then and all the Galahad series and all will be there. Was there? But I know whether it is still there. So don't depend upon those books. Market for the judicial examination preparations, read the scheduled books, commentaries and decisions, and also go through the cases going on in a court. Right, Ari? It is the practical purpose. So see how the bill is filed, orders are passed, and its execution is ensured. That is from the stage to judgment. Similarly, for the criminal case, from the stage of registration of a crime, production of the accused, trial, and up to the stage of judgment, whether it is conviction or whatever it is. We must all know that what is law? Law is a codified common sense. Nothing, law is not a science as such. So laws are essentially formalized and written collection and understanding that people generally agree as a right or just. It is prescribed for the prudent man. Prudent man. That is the law. Primary purpose of the law is to maintain order and stability in the society by establishing the standard of behavior, resolving disputes, protecting individual rights, liberties, and promoting justice and fairness. Court is to interpret. Why the court? So you become a judicial officer, and what is your duty? Court is to interpret and apply the law, and thereby enforcing the law. That is why it is said that court is to administer the justice in accordance with the law. So earlier law or earlier justice is different. Real justice is different. The court is meant to administer the justice in accordance with the law. I can tell so many examples. I can quote so many examples from my experience when the justice and the law differentiates. And even if you decide the case, generally it will not result in rendering the justice. We will also always want administration of justice in accordance with the law. See, the law is also a science. Sometimes it is a science as it involves the grasping of principles, procedures, and application of legal knowledge. Focusing on subjects like constitutional law, procedural law, and the specific statutes. So we have to concentrate on constitutional law, procedural law, and the specific statutes. So beginning I said why the stakeholders are insisting that there must be some practice, some years of practice is that what is their evidence is that the newly appointed judicial officers are lacking the experience, practice. They know everything except application of it in a practical way. There is a method to read and understand the law. See, there is always a difference between the reading of a novel or law books. You have to read the objects of the statute. So what is meant for law? Every law comes with a purpose. You must know that. If Rent Act is come, it is a purpose. If Domestic Violence Act is passed, there is a purpose. For a IPC, there is a purpose. Every act comes with a purpose. So where will you get it? You get it from the object. That is to say, what purpose of enacting the particular statute. It is often stated objects of the statute are the key to open the mind of the legislatures. That is said. So you have to understand the language used in the statute in referring to the purpose for which it is enacted. So that is we cannot be a distinct meaning to all the country words used in a statutes. That is why in most of the statutes, one chapter is dedicated for what? To the definition of the certain words used in a statute. So, for example, minor. It may be in one section it will be that minority is up to 16 years. In another statute it may say that minority is minor means up to 18 years. So you have to read that. So that is why most of the statutes are read and reread and understand the law. By hearting the provisions will not help in any way. I will tell you again and again, by hearting will not help. Develop the habit of analyzing the provisions by questioning what is the purpose. You have to analyze. That is the purpose. What is the purpose of particular provision? Why legislature has passed the statute? Focus on understanding, not memorization. Read it by understanding in each of mind. Always we used to tell to younger students and all. Same is applicable to all. Don't memorize the sections. Understand the underlying principles and how they are applied. How and how they can be applied also. That is also important. Read the decisions of the higher courts on the subjects to understand the provisions. Most of the time, decisions of higher courts will be in the form of commentaries on the provisions. Studying of landmark decisions are important. Landmark decisions you have to read to understand the legal precedents and how the provisions are interpreted. For example, when you go for civil matters, you read the Vinit Sharma case, Revar Siddhartha case, so many cases are like that. Read the statutes by dissecting the provisions and try to understand the provisions in entirety. To effectively understand the provisions in the statute, you have to start with the literal interpretation. There is a lot of interpretation, you may know that. I will tell that literal grammatical interpretation you have to give. Read the entire statute and consider the context, purpose and legislative history and pay the close attention to key words and phrases used in that provision. You have to cultivate the habit of reading the provisions without the aid of commentaries and the decisions. Don't go suddenly up to the commentaries. First read the statute, understand it, again read it, dissect it, understand it, if necessary, then go for the commentaries and the decisions. There are procedural laws, substantive laws. You all know that is the civil procedure code, criminal procedure code, some procedure laws, TP Act, Contract Act, or this one. That is the substantive laws. Our constitutional laws lies all the laws about lies. What lies? Constitutional law. All the laws are subservient to the person who is not the conductor. He is not going to be that's why that constitution is supreme law is succeeded in the case. But we must rewrite the judgment in a way that the lost person must know that why my case is filed. So in that way, you have to simple language. Yes, again I am telling you, if you write it in a Kannada language, it is far better. Because always the important, because especially in district judiciary, it is been again and again it has been told that you should write judgments in Kannada language, but there is a difficulty. If I go on saying it, I can tell in weeks together, I can tell why it is not called in law. So keep in mind that answer papers are evaluated by senior judges like us. Read and understand the preamble of the Constitution, fundamental rights, fundamental duties, federal structure, basic structure, and the power of the Parliament to amend the Constitution. This is all the important aspects you have to go through in a Constitution. There are some constitutional principles you may know it, doctrine of ethics, doctrine of intent substance, doctrine of severability, doctrine of basic structure, and so on. See, when we go to the examination, when you evaluate that, they have written some answers. You are surprised to see that that is the knowledge level of the process. So you have to be that line. It is not expected that you should write a thesis on the subject. What is expected that you have to convey the subject that is known to you. So in the examination, what you generally do, you will assess what you know. That is important for as an evaluator, as an examiner. I must know what you understand. That is the intention of the examination. I suggest you read and understand the entire Constitution. First read the entire Constitution and then concentrate on important subjects. That is to say, start with the preamble and then explore its structure. That is the parts, articles, and sentences. Focus on clear principles like fundamental rights, separation of powers, and so on. As I stated earlier, read the landmark decision that I interpreted the Constitution, the destination of the authority, open, Maneka Gandhi. You know what is the Maneka Gandhi? It is not Maneka Gandhi. It is Maneka Gandhi. So, SR Bhamai is something also. I am stressing the point that law books cannot be read as a novel. I already said. And stories. As you all know that laws are two types. One is the procedural law and substantive law. So, substantive law, what is the substantive law? In general terms, becoming the question, which is the substantive right you are going, substantive thing you are going to, you are thinking of. What is the procedure? The examination, writing, preparation, that is all the procedural aspect. In that manner, procedural law, they are the substantive laws defines the right, obligation and liabilities, while procedural law applies the methods and rules of enforcing those rights, resolving the disputes and essentially focusing on what and how the legal matter. So example, Indian Penal Code, BNS, Contract Act, Transport Liability Code, it are prescribed statutes in a practical way. Again I am telling, it may be difficult, but I am telling practical way how it is to be applied in a case. For example, when we transfer of property act, you must visualize the sale, lease, deed, mortgage in a practical way. It is a better way to study. When you are being the lease subject, read that yes, one person is listed upon this. Demands what he should do. Yes, I want to terminate the lease. What is my remedy? And he is not paying the rent. What is my remedy? Yes, I ought to borrow the land. I am going to the bank and mortgaging my property. What is the mortgage? Yes, I am going to purchase the property. I am going to sell the property. How my right to get convened? Agreement for sale conveys the right. It is only a contract to be performed. It is not a performed. It is not a absolute contract. There is still something which is to be performed. In that way, there is a practical applicability or understanding. Procedure laws meant to ensure that legal proceedings are practicing individual throughout the legal system. What is the main case is that for the procedural law is that cases should be heard and how orders should be enforced. Procedural law prescribes the principle of any alternate order. So here the other side. So that is the procedural law. A procedure must be parallel. There must be fairness in procedure. So see, for example, Evidence Act means you can't produce everything in the reports. There is some important documents for the sake concerning the safety of the country. You can't sum that up. Sometimes wife and husband communication, privileged communication. You can't say whether your husband said that I committed a murder or something like that. That is why the entire relationship, marital relationship, like that advocate and client, there is a privileged communication. A person may go and say that I murdered that person, please may defend me. But whether that advocate can be cited as a witness and can ask that whether it is acknowledged a confession because he admitted before you, tell before the courts. So that cannot be done. So in that way, that is the stage. BNSS and BSS are recently added syllabus. That is the added syllabus. All of us know that there is not much change in these acts except rearranging the provisions. It is commented that these acts are nothing but old wine in new bottles. But I say that they are revitalized wine in new bottles. So you can't say that all are completely rearranged. In BNSS, some new provisions are added. New technology being made as a part of investigation. There is some changes, zero FIR. There is so many changes. Some drastic changes are there. You can study on that. And technology is made part of investigation. So as far as BNSS is concerned, provisions are rearranging. No? Because rearranging in a better way. So it is easy now to understand. Because earlier to murder you have to go 302, for rape you have to go 376. Now it is made as index judgment, index provision I say. Apart from that, some additionals are also added. For example, what is so many other this one are added. So organized crimes are added, snatching of this are added. So you have to adopt the rule say again. So much. So if your debit card is snatched earlier, which provision has to be used? That was the question. Now it is that is also added in the EMS. So BSA is almost same. I am not telling. But except some changes in the receipt of the electronic evidence, other aspects are same as good as. But what is the problem is that you have to, section wise you have to study. You have to adopt the procedure of learning the equivalent provisions or in this act and the repeat acts and understand about the provision. For example, arrest and not be, etc. I have to say, for example, for the bail application earlier it was a 436, it is now 470. So for writing of the judgment, it was 353, now it is 392 of BNSS. Like that, you have to take that indexing there. You have to make it. So many books are available. What is the changes they have already and made, what is the changes we last year and all. You have to make note of it. Then read the statute to understand again and telling, repeat it. There will be. So you have to know the procedural law to understand how the judgment is to be written. It is very important to understand the procedural law to how the judgment is to be written. For example, if you read the trial court judgment, you will start from the facts of the case, then arrest, then bringing up the charges and bringing up the issues, evidence, issues, bringing answers. That all we will get in the this one. For example, so context becomes knowledge. So prescribed procedure laws, whereas substantive law governs the contents of the judgment. Contents of the judgment is governed by what? Substantive law. What is the procedure? That is governed by the what is the study purpose for any study? Your aim should be convert the information into knowledge. So that is the process. That is what is not what now happening. You have got lot of information. You will get by a click of mouse. You will get the information. But whether it is converted into knowledge, that there you are not up to the mark. So the information that processed and understood in context, it becomes a knowledge. Enabling comprehension, interpretation, and application is information is nothing but a lot. You can get any information. If you put your mouse and say that murder, you get thousands. Judgments of murder, you get thousands. You can read it. But in the end, your knowledge is zero. Information is yes, very high. That depends upon your memory or Information is a raw data, where knowledge is information that has been processed, understood and applied. Converting the information to knowledge is the context. You have to read the critically asked questions, discuss, debate, apply the theoretical concepts to the practical scenario. To understand the law, you have to read the critically asked questions, discuss, debate, and that is all. Thus, my suggestion again is to read in such a way that information you receive will convert it into knowledge. As stated earlier, you intend to become a judicial officer, join the office as advocate, in practicing both civil and criminal side. Don't go for advocate practicing mainly at high court. So if you want to become the judge, this one, so such office will get a practical aspect of the cases, which will help to great extent to understand the law, excel examination and face the interview also. So better, sir, I am telling because Makudima one word is there, one I like that. ಪುಸ್ತಕದಲ್ಲಿ ದೊರೆದರೆಯು ಮಸ್ತಕದಲ್ಲಿ ಕಳೆದ ಮಣಿ ಚಿತ್ತದೊಳು ಬೆಳೆದೆರವು ತದು ತಲೆದ ಪುಷ್ಪ ವಸ್ತು ಸಾಕ್ತಾರ ನಿರೀಕ್ಷಣೆಯಿಂದ ಸಾತ್ವಿಕನದಿಂದಲ್ಲ ಅಂತಂದ್ರೆ ಪುಸ್ತಕಗಳನ್ನು ಹೊರತು ದೊರೆತ ಜ್ಞಾನ ತಲೆಯ ಪುಸ್ತಕದಲ್ಲಿ ಮಾತ್ರ ಇರುತ್ತೆ. ಆದರೆ ನಮ್ಮ ಮನಸ್ಸಿನಲ್ಲಿ ಬೆಳೆಯುತ್ತ ಅರಿವು ಗಿಡದಲ್ಲಿ ತರು ಬೆಳೆದ ಹೂವಿನಂತೆ ವಸ್ತುವಿನ ಸಾಕ್ಷಾತ್ಕಾರ ಪ್ರಾಕ್ಟಿಕಲಿ ಒಳನೋಟದಿಂದ ಒಳನೋಟದಿಂದ ಹೊರತು ಪಾಂಡಿತ್ಯದಂತಲ್ಲ. So you must understand it, that you must understand any complication. You may practice it, but understand the law, understand the subject. That is much. You must have a basic computer knowledge. If it is your part of syllabus in the college, it is okay. Otherwise, it is to be learned from the outside. You can get the issues, charge, deposition, preliminary statement, orders, and judgments of the trial courts in their respective websites. For every district court, there is a website. So you can get all the formats. You can select any judges if you like it, or if any judgment, any matters, you can get it. You can download it, all the PDF copies. You can get it in Kannada language also. So it is easy to now get the copies. In our time, it was not like that. You used to go to the office of the advocate, or you have to request some court staff for the judgments and copies. And all, but now I am telling materials are in evidence. How to use this one? So formats your mind. So why you have studied? You have to study them well, and you must picturize the formats in your mind. Why I am telling is that to write the judgment, to frame the charges, to write the judgment, you must have the format. Format is very important. If you write the format, I as an evaluator, I will get 10 marks. It is guaranteed for you, even if there is nothing on the content. So format is also important. For judgment writing, if you write it easily, for example, if asked to tell what is the case, facts of the case, then you write an accused and all. If you have to use this format wise, it is come. I will give you 15 marks, 10 marks. Because before everything, it will be told how to mark it should be given to them. So there are informative YouTube channels. There are many. So legal news platforms. You may be on bar and live law. Okay, there are so many. That's a legal. There is Karnataka judgment you get it. They are giving the law prize for the students, especially law students. I heard it because I know that Kasara deduction because we have 40 judicial officers also. So us also is giving some concessions. So suicide law series Friday book is there. So Judicial Academies are including Karnataka Judicial Academy, Judicial Academy. They are all disseminating their knowledge through their YouTube. It is publicly available to the YouTube channels. They are all their own YouTube channels. There are own online research platforms such as SSC Online, Muthappa, CDJ, Live Law, Bar and Bench, Daksha Legal, Word Income. One more aspect I am telling you, EILR is available in Karnataka website. It is free. Which is available in the brand and it is available. And so watch the live proceedings of Karnataka High Court. So you get a Supreme Court website. Lives also get you get the hearings in the archive column. Archive section is there in the Supreme Court website. You get all the so far whichever hearings were live casted will be available there. Apart from the law books, you have to read the general books. So again, I am telling general books are necessary. Don't, one thing again I am stressing, don't get the impression that my English knowledge is good. I am English medium, I back with this one. No, if you read both Kannada and English. So I think I will stop here and then I will continue later. So something about translations and then I will. So my last suggestion is that abundance in YouTube, mix them in the book. So hybrid is the now the system, not either don't depend entirely on YouTube and searching. You have to be hybrid. So both will be there. Don't depend upon online reading only. Yes, there is a abundant reader. Read the books, read the commentaries. Apart from topics, read. Yeah, so I am thinking whether Sarfraz will take up that, then I will speak a little bit upon how translation is important for the future. I think this, I stop here. Thank you.